Good afternoon and a very big welcome to the next Your Employment webinar in the series, providing you with essential employment law and HR updates. And today's webinar has a special focus on the grievance process and some tricky legal issues related to the same. For those of you that are new to our webinars, we are Jones Chase, a firm of specialist employment lawyers, and we act for a number of companies from PLCs all the way through to startups and also some fantastic individuals as well. And I'm pleased to say we have a very high success rate of looking after those that we represent. And yeah, we're truly delighted to have you with us today. So thanks for attending. And I'm just going to quickly introduce the team. We've got one of the firm's senior associates, Harry, just going to speak to us today.
Good afternoon, everyone.
And we've also got one of the firm's paralegals, Dominic.
Hi.
And on her very first webinar, we've got the firm's new paralegal, Jessica Gibbs.
Good afternoon.
Okay, great. So first of all, in terms of format for the webinar, if you want to ask us questions, and of course we have promised a live Q&A session at the end of the webinar, use the Q&A box or the chat box as well. If you want to ask the question on an anonymous basis, there's a button to do that as well, so make sure you press that. We will never refer to your full name or the name of the company, so don't worry about that, but we may call you by your first name, which presumably is fine. Also, we want it's useful for the rest of the attendees to know what you're saying as well, so when you're using the Q&A box or the chat box, I believe there's a drop-down menu that you can use that says all panelists and attendees. So if you do select that option, it means everybody can see what you're saying and they can just go. It's useful to keep the flow of the conversation going. If you want to speak live, and only one person has done this in the 2.5 years we've been doing the webinars, please write this into the Q&A box or the chat box, and either myself or one of the team will unmute you so we can hear you. And I should add that we are recording the webinar and to allow us to distribute the webinar to those that couldn't make it today. So please bear this in mind if you're asking questions or you want to participate on an anonymous basis. I should emphasize that the points we're covering today are not formal legal advice, and so much depends on the facts of a particular case. So if there's something you want us to help with, then definitely drop us a line outside the webinar format. And yeah, definitely don't rely on what we say in the webinar as formal legal advice, because we do need to understand the full facts of the case before advising. And quick reminder, the information we're covering today is accurate as of 4 o'clock on the 29th of September 2022. Things always change quickly in employment law, so do drop us a line if you have any further questions. And lastly, we do like helping people, so if there's anybody out there that you think would benefit from these webinars or for us helping them as legal advisors, definitely ask them to get in touch with us. It's always good to expand our network. Okay, so moving on quickly with the content. As ever, we have an awful lot to cover today. And as I mentioned earlier, the focus of today's webinar is the grievance process. And in Jones Chase, we're big believers that getting the grievance process right can result in significant savings, both in terms of time for the employer and also money. And of course, getting it wrong, however, can itself lead to claims being brought, for example, for constructive dismissal, and some discrimination claims can be brought purely by carrying out a deficient grievance process, so do bear that in mind. And I should also mention that we do enjoy getting instructed early on in a case as well, because there's significant gains that we can help the company with if we get instructed early. Primarily two things. Firstly, we can help you to take steps to minimize liability and to prevent claims from being brought whenever we're involved in the case of the formative stage, because at that stage we can have a hand in controlling and creating evidence, which is hugely beneficial. And secondly, often forgotten, is that if you work with lawyers at an early stage, a lot of the correspondence can be covered by legal advice privilege where relevant as well. And that's really helpful if there's a difficult decision to be made or some difficult documents to draft. If you're working with lawyers, you can protect those documents and those discussions with legal advice privilege, meaning that you won't have some horrible pieces of disclosure go into the tribunal that you'd rather the judge wouldn't see. So that's another advantage of working with lawyers at an early stage as well. Okay, so moving on quickly with the content. Our first speaker is Jessica, and she's going to speak to you about basically what is a grievance and the grievance process generally. So over to you, Jess.
Hi, thanks, Dean. So yes, I'm going to speak about the grievance process. And just to start with, what is a grievance? Put simply, a grievance is a concern, problem, or complaint that an employee raises with their employer. This may be a concern about their working conditions or environment, or about someone they work with, including management, or something else that's made them feel unjustly or unfairly treated at work. It can be verbal or in writing, though the ACAS Code of Practice, which I will cover shortly, states that the grievances should be put in writing. Many potential grievance issues can be resolved informally. Sometimes just a chat with a line manager is all that's required to resolve an issue. However, where it cannot be resolved informally, the grievance procedure is a formal way for an employee to raise a problem or complaint about their employer. Organisations may wish to consider dealing with issues involving bullying, harassment, or whistleblowing under a separate procedure, and this will be discussed later in the webinar. So, who can raise a grievance? Strictly speaking, the ACAS Code of Practice applies only to employees of the organisation. Therefore, all current employees can raise a grievance, but it is good practice to have mechanisms in place to deal with grievances raised by workers and also employees who have left employment. Furthermore, there is no obligation to consider grievances raised by job applicants, but again, companies may wish to do so if there is a risk of a discrimination claim being brought. To be clear, however, there are no direct financial consequences other than ACAS uplift, which I will deal with shortly, if a company fails to deal with a grievance by anyone who is not a current employee. So, the ACAS Code of Practice. The starting point for considering grievance procedures in the workplace is the ACAS Code of Practice, which sets out the basic requirements of fairness which will be applicable in grievance procedures and the general standards of reasonable behaviour. The code provides practical guidance to both employers and employees, and it should be referred to in situations where the grievance cannot be resolved informally, as I've just said. So, although the procedure set out in the code is not legally binding, it's commonly referred to in employment tribunal proceedings when determining whether the employer has acted reasonably and also in the fairness of the decisions that they make. Employers can be penalised in certain situations for failing to follow it. In addition to the principles of fairness in the code, an employer should also be familiar with the ACAS's supporting non-statutory guidance on discipline and grievance at work and the Guide to Conducting Workplace Investigations. These documents provide comprehensive advice on dealing with grievance situations and contain sample grievance procedures. Unlike the Code of Practice, the supporting guides do not need to be considered in tribunal proceedings, so employers can't be penalised for not following them, but they do provide really helpful guidance based upon good industrial relation practice and just generally how to run grievance matters. These documents are available on the ACAS website, www.acas.org.uk, but feel free to drop us a line if you're having trouble locating them. So, ACAS uplifts and downlifts, as I've just mentioned. Although an employer's failure to follow the ACAS code cannot in itself form the basis of legal proceedings, it will be considered by an employment tribunal in relation to other claims. So it's an important reminder, if the employee brings certain successful claims, such as a claim for unfair dismissal, the tribunal can adjust the amount of compensation awarded to the employee by up to 25%. And this is commonly referred to in tribunal proceedings as an ACAS uplift. Conversely, the tribunal can decrease compensation awarded to an employee if the employee has brought a claim but has unreasonably failed to comply with the ACAS code themselves. This is commonly known as an ACAS downlift. So that percentage adjustment can either increase or decrease the total amount awarded to the claimant and is based on whether the employer or the employee has unreasonably failed to comply with the ACAS code. This is an important fact to bear in mind for businesses and for HR executives, as the ACAS code generally imposes more obligations on the employer. The ACAS uplift and downlift does not apply to all claims, but does typically apply to those most well-known. We can supply you with a checklist if needed, but either way, generally we recommend complying with the code in the first place. So now I'll turn to company internal and contractual procedures. So company grievance policies and the information basically that they should include. It is a requirement of Section 1 of the Employment Rights Act that employers provide their employees with details of their company grievance procedure. The grievance procedure must be available in a reasonably accessible document, such as a staff handbook or on the company intranet, and it must be provided within 2 months of the employment commencing. So the grievance procedure should clearly state who the employee should contact about a grievance, such as their line manager, and how to contact that person. That if the problem can't be resolved informally, there will be a meeting with the employee, and this is called a grievance hearing. It should set out the limits for each stage of the process. It should identify who to contact if the normal contact person is involved in a grievance. It should explain how to appeal the grievance decision, and it should state that employees can be accompanied at any meeting by a colleague or union representative. It is important to note that details of a company grievance procedure do not need to be included in the employment contract. In fact, it is preferable to provide the grievance procedure in a non-contractual document, most commonly the staff handbook. Giving a grievance procedure contractual status means that the company is legally bound to follow each step exactly, otherwise be vulnerable to a breach of contract claim. So by having the procedure as a non-contractual policy, this risk is avoided. As such, our Jones Chase's advice is we always recommend that a company's grievance procedure should be non-contractual, which will provide you with some flexibility and avoid the company being overly punished by way of a breach of contract claim if you fail to follow one particular step. If you want us to review your grievance procedure to make sure that it's fit for purpose and properly protects the company, feel free to drop us a line. So next question is, do you need to investigate? The short answer is yes. Whilst there is no bespoke paragraph in the ACAS Code of Practice dealing with the investigations for the grievance process, as there is for disciplinary processes, paragraph 4 of the same refers to basic principles of fairness that need to be applied by employers when running a grievance procedure. So the code states that employers should carry out any necessary investigations to establish the facts of the case. In our view, whilst it is possible to cut corners in certain cases, an investigation of some kind should always be carried out to allow the employer to find out all they reasonably can about the issue. Making a decision on a grievance without first completing a reasonable investigation could render that decision unfair and leave the employer vulnerable to legal action. Failure to carry out a reasonable investigation could also be considered in relation to an ACAS uplift, which I've obviously already mentioned. However, the length or degree of detail required in each investigation will vary, and the size and resources of the employer can be taken into account in the tribunal. So here are 8 top tips when dealing with a grievance investigation for you to follow. So number 1, make sure that your investigator is suitably senior and experienced, depending on the complexity of the matter. If the evidence to be investigated is particularly serious or complex, involving, for example, allegations of discrimination or bullying, consider using someone who has the appropriate training. Number 2, make sure the investigator is not personally involved in the matter, obviously, being investigated, and there are no conflict of interest concerns. A failure to do this could arguably be a breach of the rules of natural justice. Number 3, draw up good terms of reference for the investigation to set the precise purpose and scope of the investigation and to set out the investigator's role and responsibilities. We can help you with this and all of the other steps I'm talking about if that's needed. Number 4, request that your investigator forms an investigation plan at the outset of the matter, as is recommended by the ACAS Code, and make sure that the plan is in order before the investigation commences. Number 5, keep an open mind and be flexible during the course of the investigation, particularly if new evidence comes to light. Be prepared to make changes to both the terms of reference and the investigation plan. Number 6, ensure that confidentiality during the investigation process is maintained and brief your investigator about this requirement. This also applies to any witnesses who are being interviewed, and they should be expressly instructed to keep matters confidential. Also, you can consider how much information you reveal to the witnesses. Number 7, important, act promptly. A failure to not do this allows memory to fade, but could also render the employer liable to an ACAS uplift for not acting without unreasonable delay. And number 8, lastly, whilst there is more that I could say on this topic, do bear in mind that documents generated during a grievance investigation will be disclosable documents in any tribunal proceedings, and could make the company vulnerable, and can be vulnerable to be disclosed at a data subject access request. As Dean has mentioned, using lawyers such as Jones Chase to help with the grievance process can help sensitive documents relating to difficult decisions having to be made can be covered by legal advice privilege and therefore protected from disclosure. So finally from me, who should hear the grievance? In grievance matters, the investigator and the decision maker can be the same person. In fact, ACAS suggests that the grievance may be resolved more satisfactorily if the person investigating the matter also hears the grievance. This is an important distinction to the investigation and hearing of disciplinary matters, where ACAS advises that different people should carry out the investigation and hearing. The person hearing the grievance should be impartial and should not be involved in any of the issues that have resulted in the employee raising a grievance. If during the course of the grievance hearing, facts or matters come to light whereby it's clear that the chair is in some way involved in any of the matters, the meeting should be adjourned and a more suitable chair found. A failure to do this exact same thing has led to a successful finding of discrimination in a previously reported case. Lastly, the person hearing the grievance should be sufficiently senior to be able to make appropriate decisions and take appropriate action within the organisation, particularly if the grievance is upheld. You also want someone who is going to behave well, keep calm, be objective, and represent the organisation well. And that's everything from me.
That's great. Thanks very much, Jess. That was fantastic. Appreciate it. And we've had 2 questions in, just 2 so far. I would have thought more would be coming in by now. One from Caroline and one from an anonymous attendee. So we will deal with those at the end of the webinar, but do keep your questions coming in. That's kind of why we're here today. We did promise we'd do that as well. So moving quickly on with the content, moving on to Dominic, who's going to discuss a batch of tricky issues that get thrown up in the grievance process. So over to you, Dom.
Thank you, Dean. So as Dean mentioned, now looking at situations which may cause issues for employers and how best to handle them. So firstly, looking at what to do if an employee goes off sick. It is not uncommon for an employee to raise a grievance prior to or during stress-related sickness absence. So in such cases, the reason for the sickness absence is often directly related to the workplace issues which form the basis of the grievance, and the employer must tread particularly carefully in handling the situation. Although it is important to keep in contact with an employee who is on sick leave, it's important to avoid overbearing or intrusive contact. Additionally, even if the employee goes off sick for reasons unrelated to the grievance, it is still advisable to ask them if they believe they are fit to attend the meeting. It may be appropriate to obtain a medical report on the employee's condition and assess whether any adjustments could be put in place. It is possible that stress could amount to a disability under the Equality Act 2010. Obtaining a medical report will assist the employer in determining whether this is the case. If the employee concerned is disabled, then consideration should be given to the disability discrimination provisions of the Equality Act 2010, particularly the requirement to make reasonable adjustments. However, even if the employee is not disabled, it may still be reasonable for the employer to adjust the venue, and other arrangements for the hearing in light of the employee's illness. The employer must be mindful of his express and implied contractual duties, including the implied obligation to offer reasonable and prompt redress of any grievance, and the implied duty of trust and confidence. If the handling of the grievance breaches these terms, then the employee may be entitled to resign and claim constructive dismissal. Overall, it would be generally unwise to conclude a grievance without meeting with the employee and giving them the opportunity to explain their concern. If you need advice in relation to a particularly difficult case that you are working on where sickness is an issue, please feel free to get in touch with us. So now looking at the difference between a grievance and a bullying and harassment complaint. I know Jess mentioned this earlier, but a grievance can cover other employees, but also that of their employment rights. As a short summary, bullying can be described as behaviour that is offensive, intimidating, malicious or insulting, or an abuse or misuse of power that undermines, humiliates or causes physical or emotional harm to someone. Bullying can be a one-off incident or it can be a regular pattern. Similarly, this is not a talk on harassment, but in short, the general definition is a person harasses another if they engage in unwanted conduct related to a relevant protected characteristic, which has the purpose of or effect of either violating the other's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for the other person. This is important as an employer may be liable under the Equality Act 2010 if it fails to protect its employees and other workers from harassment in the course of their employment. This includes harassment by members of staff, and in some cases by third parties such as customers, service providers, and visitors. This is therefore a statutory claim, and compensation may be awarded by a tribunal. It can also, of course, be damaging for the employer's reputation. The reason why the distinction is important, though, is due to how the employer should be handling differing processes. There is a more stringent requirement on the employer for harassment and bullying issues than there is for grievance-related matters. the law does not require an employer to have a separate policy on bullying and harassment, which can be dealt with under its grievance procedure. However, many employers have a separate policy with a more detailed procedure for investigation in recognition of the sensitivity and seriousness of such complaints. Case law also suggests that this may help to establish a reasonable steps defence to a claim under the discrimination legislation. I should also add that in certain circumstances, the way in which an employer carries out its investigation into a grievance alleging discrimination or harassment could in itself result in a discrimination claim, and there is a lot of case law supporting this. Therefore, care must be taken. In addition, in the introduction section of the ACAS Code of Practice, it states organisations may wish to consider dealing with issues involving bullying, harassment, or whistleblowing under a separate procedure. From Jones Chase's perspective, we always recommend having a separate and more detailed bullying and harassment policy, as it can be used as evidence that the organisation takes such matters seriously. And once again, if you need any assistance with preparing such a policy or want to know what to put in there, do drop us a line. So now turning to whether the employer should offer the chance for the employee to appeal the outcome of the grievance. So the ACAS Code requires that the employee is offered a right of appeal. A failure to do so could lead to an uplift in any compensation subsequently awarded to the employee by an employment tribunal. If the employee wishes to appeal, they should set out their grounds of appeal in writing without unreasonable delay. While the non-statutory ACAS guide recommends imposing a time limit for disciplinary appeals and suggests that 5 working days is often enough to appeal a disciplinary decision, it does not make any similar suggestions in respect of grievance appeals. This does not mean that an employer cannot set a deadline in its grievance procedure for an employee's appeal to be received. However, if the employee fails to meet the deadline, the employer should consider carefully whether it should still consider the appeal. As a reminder, getting the grievance appeal right is important, not least because a failure to provide a fair and impartial appeal could lead to a constructive unfair dismissal claim. The appeal chair should be impartial and, wherever possible, not involved in the original decision and more senior to the manager who made the original decision. In smaller employers, this may be impossible to achieve, but in such circumstances, the person hearing the appeal should act as impartially as possible. I also wanted to mention what happens if fresh evidence arises at the appeal stage. Unlike with disciplinary matters, there is no guidance relating to this in the ACAS Code or the non-statutory ACAS Guide. That said, employers should act carefully and not ignore the new evidence. In such circumstances, it may be worth carrying out a full rehearing of the grievance at the appeal stage, rather than a more simplified review of the original decision. That would particularly be the case if the grievance concerns serious and wide-ranging issues. So now looking at communicating the decision to the employee and how best to do so when the outcome is against the employee in question. The employee must be informed without unreasonable delay of the action the employer has decided to take to resolve their grievance and of their right of appeal. Although the ACAS Code requires this to be in writing, it is good practice once the employer has reached a decision to reconvene the meeting and provide the employee with a face-to-face explanation of the steps the employer intends to take. Resolving a grievance in a way that is suitable for all parties can be problematic. As a firm, we strongly recommend that the employer submits as much factual evidence as possible in support of its decision. This makes it harder for the employee to appeal against and may also allow them to understand the employer's rationale for rejecting the grievance. Using suitably firm, clear but empathetic language is also recommended. In some cases, resolving the grievance may require separating 2 or more employees from each other. Relocating an employee who has raised a grievance concerning the conduct of colleagues can be difficult and may be a situation in which workplace mediation is appropriate. However, in some circumstances, relocating the employee to a different location altogether may also be appropriate. It may be best for the decision maker to talk privately with the employee to ensure that there is no bad feeling that remains. It must also be considered whether raising an entirely unfounded grievance by the employee was them acting dishonestly, but Harriet will cover this more in detail later in the webinar. If any of the allegations raised in the grievance fall into the category of a protected disclosure, the employer will also need to ensure that it does not take any action against the employee which would amount to an unlawful detriment. So finally, looking at what employers should do when grievances are raised by ex-employees. So there's no explicit requirement in the ACAS code for an employer to follow a grievance procedure in cases involving former employees. The previous regime under the Employment Act 2002 explicitly required a former employee, for example, one who had claimed had been constructively dismissed, to submit a written grievance before bringing a claim. The parties then had to follow a procedure, although if both parties agree, it could merely be an exchange of letters. However, in the case of Base Children's Wear Limited and Otshudi, the Employment Tribunal awarded an uplift of 25% in respect of an employer's failure to follow the ACAS code or respond at all to an employee's grievance submitted after her dismissal. The employer appealed other aspects of the compensation award, but did not appeal the uplift. On appeal, the Employment Appeal Tribunal made no overture comments disagreeing with the tribunal's approach. In light of this, it would be advisable for employers to always follow the ACAS code in respect of post-termination grievances. It is also not uncommon for employees' resignation letters to set out grievance issues, particularly in a constructive dismissal situation. If an employer can resolve the employee's issues under its procedure, it could avoid a future time-consuming and costly tribunal claim. And that's all from me.
Okay, that's great. Thanks so much, Dom. Really appreciate that. And well, so far we've had 3 questions in, 4 actually. So again, we will deal all of these at the end. Just to let the team know as well, I can answer the first 3. I don't want to hog the show though, so maybe the first one, me and Harry, we can discuss that as well. I can cover the second one and the third one, unless Dom or Jess want to jump in on that. Dom, that was your section about appeal, so if you want to speak about that, you can. And we've had a new one in I haven't read, but just moving quickly on. And Harry's now going to discuss the final batch of tricky issues that crop up during the grievance process. So over to you, Harriet.
Thank you, Dean. And apologies if my screen keeps freezing. Hopefully you can still hear me, even if you can't see me properly the whole time. So yeah, I've got a few more tricky issues to chat through. And obviously Dom talked about what happens when you get the outcome of the grievance, potentially when you're not upholding it. So wanted to just have a think about what if the outcome of the grievance is that the company may be in the wrong. So you've had the investigation and the outcome, and the employee did have a valid complaint, and the grievance may be partially or fully upheld. Is there anything you can do to try and sort of minimise your liability going forward? So obviously it's going to depend a little bit on what the nature of the grievance is, and starting with sort of more straightforward to start with. If it was something that could potentially be a breach of contract, for example, money due to the employee for commission or bonus, make sure you put that right in a timely way. Give the employee what they are found to have been entitled to. It may also make you want to think about, are there any amendments that you might want to make to your contract of employment template, if it's something which has arisen through the contract which could have been avoided, or potentially amendments to policies and procedures. You might want to give them a review. Grievances often concern relationship issues, classically an individual with their line manager or another manager. If the situation isn't one of discrimination and things haven't gone too far, workplace mediation between the complainant and the perpetrator can be a really good idea to try and rebuild that relationship and help everybody move forward. And obviously potentially training for the line manager depending on what the issues were in terms of leadership, etc. If the complaint concerns discrimination and it's been upheld because obviously something serious has happened in the workplace, then that is a bit more tricky and does require some thought. And as we've already heard, the way you deal with a grievance, including follow-up after the outcome of the grievance, can itself lead to further claims of discrimination, including victimisation. And that can also include a lack of action. So if you don't take the steps that you should take. Obviously, you need to give feedback to the complainant about sort of what further action is going to be taken, and the sorts of things that might be appropriate could potentially be a disciplinary process being run against the perpetrator. That's obviously a completely separate process, and the outcome of that shouldn't be shared with the complainant. That's something that would be dealt with separately with the individual concerned. Equality training, this can be really important. Obviously, if the individual did decide to pursue a discrimination or a victimisation claim, if you can then show that you've done all you could once you were made aware of the issue, then that's help, and certainly might help if there were any further issues within the company to help prevent this from happening again. And obviously, as I said before, reviewing policies and procedures. If you didn't have an equality process or a bullying and harassment process, you might want to then put that in place and make sure that's publicised well within the company. Constructive dismissal has also already been mentioned, that the way that you deal with the process and what's happened could potentially give rise to an individual claiming either a breach of the implied duty of trust and confidence or the implied obligation to give reasonable redress of a grievance. So again, important you take appropriate action. But one thing to be aware of on this front is there was a Court of Appeal decision in the case of Buckland and Bournemouth University Higher Education Corporation a few years ago, which said that an employer cannot cure its repudiatory breach of contract by its conduct after the event. So one, an employer can attempt to make amends for a repudiatory breach, which, for example, could be discriminatory harassment, through the grievance process. If the employee decides to go down that route of resigning and claiming unfair constructive dismissal, there's not much you can do to affect the merits of that case. But obviously, the more that you can do to try and rebuild things, to try and make amends with the employee, the less likely they are to litigate. So, as always, it's important that you do try and take steps to resolve things to make it less likely that the individual is then going to take further steps. So looking now at sort of unfounded, malicious, tactical grievances, I think firstly with unfounded grievances, you do need to be a little bit careful. I mean, obviously this could be potentially a disciplinary issue if the employer considers that the employee has acted dishonestly. Or it could lead to a breakdown in trust and confidence, or sort of some other substantial reason dismissal, which I'll come on to. But if the individual has simply sort of been mistaken regarding what they've complained about, rather than it being actual dishonesty or acting maliciously, it wouldn't usually be appropriate to take any disciplinary action against them. And if the allegations fall into the category of a protected disclosure, so they may have blown the whistle, as Dom mentioned, you want to be really careful that you don't take any action against the individual which would amount to any sort of unlawful detriment, because this could lead to a whistleblowing claim by the employee. So even if the employee has been mistaken about the allegations that they made, and it may be that you don't uphold the allegations, they may still have blown the whistle. So you do need to be then careful about what you do next. And just on the point about if the grievance contains a whistleblowing allegation, the ACAS Code does suggest that employers may wish to deal with whistleblowing allegations under a separate procedure. So if you have a separate whistleblowing policy, obviously it would be a good idea to deal with this under your separate policy. And we would always recommend that you do have a separate whistleblowing procedure, because obviously depending on what's being raised, the issue may be very different to a personal grievance. And obviously now for protected disclosure to be one, it has to be sort of in the public interest. So it may require a different approach to one that you would take where it was an individual grievance about that person. It may be a bigger company-wide issue. So you may want to deal with it slightly differently. But the main message is you mustn't ignore something that could be a protected disclosure, or without enough thought discipline the individual or subject them to a detriment, because as you'll be aware, compensation for whistleblowing claims is uncapped, as it is with discrimination. And if the employer finds that the complaints were unfounded, but they were discrimination claims, again this could lead to potential victimisation claims. And I wanted to just illustrate this with an EAT decision, because it's something that may happen, perhaps hopefully not in such an extreme way in your organisation. But the case was Woodhouse and Northwest Homes Leeds Limited. And in that case, the EAT held that an employee had been victimised when he was dismissed after bringing 10 internal grievances over a 5-year period and 9 related employment tribunal claims. And the EAT in that case warned that it would only be in a few exceptional cases where protected acts will be found not to have caused the dismissal or other detriment. So if you are faced with employees making sort of repeated and unsubstantiated complaints of discrimination, you should consider very carefully before you take any action to discipline or dismiss them, even if you think their complaints are irrational or putting an intolerable strain on the employment relationship. and there has been some recent case law in this area in terms of this separation of the protected act that the individual has done and the reason for dismissal. You may have heard about the Kong case. And it can be very difficult to separate the protected disclosure or the discrimination they've raised from the reason for dismissal. And it's important to try and separate these. So if the individual has behaved in such a way which is unconnected to their protected act, but is other, sort of blameworthy behaviour, or the way in which they have raised their complaint has been done in a really unreasonable, outrageous way, then you want to distinguish that behaviour from the thing they're complaining about to enable you to then take action against them. So it doesn't mean you can't do anything about them. It just means you need to be really careful about separating those reasons. So what about malicious grievances? Well, the ACAS investigations guide that Jess mentioned suggests that where a grievance investigator suspects that a malicious complaint has been made, they should usually give the employee the benefit of the doubt and carry on with the process. But where the investigator decides the complaint was clearly malicious, then it's possible that action could be taken against that individual for raising a malicious grievance. And there was a tribunal case in which it was found that an employee had raised a grievance concerning his manager as an act of retaliation, and the employer was criticised in terms of how it dealt with it. And in this case, it was after the manager had given evidence against the employee in disciplinary proceedings for sexual harassment, and the employee then raised a grievance complaining about the outcome of the disciplinary proceedings. So the employee didn't appeal the disciplinary decision, but raised a grievance about his manager, disputing her evidence, complaining about her style of management, and claiming that she should have dealt with this informally, which obviously, if it's sexual harassment, would have been completely inappropriate. And the Employment Tribunal upheld the manager's subsequent complaint of sex discrimination and found that by allowing the individual to pursue the part of his grievance that was basically a complaint about the claimant's whistleblowing about his sexual harassment, the employer was at best colluding in his retaliation. So it's only a first instance decision, but it does illustrate the potential dangers in allowing one employee to pursue a grievance against another where their motives are malicious. So it's worth just having a think about that. Something which you may have come across as well is tactical grievances. So there are cases in which an employee will raise a grievance as a negotiating tactic in order to prompt settlement discussions or to gain additional leverage in existing discussions. And I would say that even if you are in the middle of without prejudice discussions or pre-termination negotiations under Section 111A of the Employment Rights Act, I wouldn't advise you to simply put the grievance on hold. Ideally, you would follow the grievance procedure in parallel with those other discussions that you're having sort of off the record, just in case negotiations break down and the individual does decide to bring a tribunal claim. You've protected your position if you've carried on with the grievance that the individual's raised. So I think even if you think it is a negotiation tool, deal with it in the same way as any other grievance. And it may be that the individual is raising a potential problem that you do need to look at. It may be a wider problem in the business in any event, even if it's been raised tactically. Looking now at the issue of what if without prejudice points are raised during a grievance process. So looking at whether if the employee raises settlement discussions during a grievance process, or if an employee raises a grievance about a without prejudice or Section 111A discussion. So how do you deal with that? So normally, if an individual raises discussions about settlement during a grievance process, those discussions would not normally be admissible in future litigation if the without prejudice rule applies. And as a reminder, this is where there is a pre-existing dispute which the parties are looking to settle. So sometimes with a grievance, it may have gone far enough that it's considered there is a dispute. In other times, depending on how far things have gone, that there may not be. It will be a question of fact. So if there isn't a pre-existing dispute, then all the discussions are going to be admissible. If the without prejudice rule does apply, then obviously any without prejudice discussions should not form part of any sort of open meetings, conversations, letters, emails. You want to deal with it all separately. So if an employee raises the issue of settlement during a grievance meeting, you should pause that meeting explain to the employee that this can be discussed on a without prejudice basis, explain what that means, and if they agree to continue the meeting, make sure that there's a separate note which will be a without prejudice document. And that way, if you don't reach settlement, you can easily separate the without prejudice discussions from evidence about the grievance itself. So what if if you have a without prejudice, try to have a without prejudice discussion with an individual or under section 111A, and they raise a grievance about that in itself. So again, if the without prejudice rule applies, the discussion and any evidence should not be admissible. So you could refuse to deal with it if you're sure. If there is any uncertainty over this, then it's normally sensible to hear the grievance in the normal way. But ideally, you would avoid this if possible. There's no guidance on how an employer should deal with a grievance about a section 111A pre-termination negotiation. As you'll probably know, evidence of pre-termination negotiations is admissible in an unfair dismissal claim unless there is is inadmissible unless there is improper behaviour, and it's likely that the rule on inadmissibility would include any aspects of a grievance letter or an outcome which refer to the existence or content of the pre-termination negotiations. But details of any of the discussions are admissible in any other proceedings. So, for example, discrimination, unless they're covered with the without prejudice rule. So just remember, it only applies to unfair dismissal claims. So, I mean, the safest approach is to deal with the grievance in the normal way. And this is because of the risk that if the individual alleges facts that could amount to improper behaviour, if those are substantiated, then you want to show that you've got a properly concluded and reasoned grievance outcome, which may then show that there wasn't actually any behaviour. So, it will protect the company's position in that regard. And also, if they're suggesting they may bring a claim that is other than unfair dismissal, so they're suggesting a discrimination claim, then again, you may want to follow the full procedure. Another option is to refuse to hear the grievance, but there are some risks with this, as I've mentioned, and also it could lead to an individual suggesting that this is a breach of contract, which entitles the employee to resign and claim constructive dismissal. The last point I want to deal with, which is quite a common one, is what if a grievance is raised during a disciplinary process? It's not uncommon for grievance and disciplinary matter to overlap. And for an employee to raise a grievance during a disciplinary process, sometimes it could be in an attempt to delay the disciplinary proceedings. And this is obviously an issue. It can be difficult for employers to resolve a grievance at the same time as concluding the disciplinary proceedings. And the individual may argue that to be dismissed whilst a grievance procedure is still going on is procedurally unfair. But an employer isn't going to want to postpone the disciplinary action indefinitely until the employee is satisfied their grievance has been dealt with, particularly if it's going on and involves lots of individuals. So the ACAS Code isn't much help here. It says the disciplinary process may be temporarily suspended to deal with the grievance, but it also says that whether discipline and grievance issues are related, it may be appropriate to deal with them concurrently. So basically gives employers discretion to deal with it as they feel is appropriate. The non-statutory ACAS guide is a bit more helpful and gives some examples of circumstances where you might want to consider suspending the disciplinary procedure to deal with a grievance. And these include if the grievance relates to a conflict of interest that the manager holding the disciplinary hearing is alleged to have had, if their bias is alleged in the conduct of the disciplinary hearing, if management may have been selective with the evidence they're supplying to hold the disciplinary hearing, or there's possible discrimination in the process. There's no guidance on how long you might need to suspend the proceedings, and you might not always need to do this. Sometimes employees submit what they call a grievance after they've got the disciplinary outcome, but that grievance may in reality be an appeal against a sanction that's been imposed on them. So you may be able to just deal with it as part of the appeal process, but it's going to depend on the facts of the case. So I think to conclude, I would advise employees not to rush to dismiss where grievance issues are still outstanding, but to have a look at this carefully, and look carefully what issues are raised, and generally, if you could have gone to some way towards dealing with the grievance before contemplating dismissal, then that will probably protect the company. But it will always be very dependent on the facts of the case, as with so many things. And yeah, I want to leave some time for questions, so I will finish up there. Thank you.
That's great. Thanks so much, Harry. I really appreciate that. So as promised, this is where it's now your opportunity to make sure that you keep the team on our toes over here. So we are now answering live questions. Just a little bit of housekeeping, I think, just to let the team know here. So I can deal with the first two in order. Dom, I think you can do the third one, if that's okay. Harry, would you mind then having a look at the fourth and fifth one, which is about continual grievances? That's part of your section anyway. Let me know if you have any problems with that. Otherwise, I can answer it as well if needed. What is the final one? I'll deal with the easiest question first. Will this webinar be shared anywhere? Yes, it will. It will be on our YouTube channel. So just go into YouTube and search for Jones Chase Employment Lawyers. We are nowhere near 1 million views per video yet, like some music stars or TV stars. However, everything does go on there. Just give us a week with that. It will also be on our website as well, in the news and events page. Okay, if you missed it. If you want to see a copy prior to it going on YouTube, let us know. We can get them emailed over to you as well. So drop me a line at dean.jones@joneschase.com. Okay. So just moving on with the questions. The first question, one from Caroline here, and I'll read it out for the benefit of people watching the recording. And the question is: a lot of grievances we are finding we have of people refusing to return to the office, refusing to return to office working post remote working. What are your thoughts on this? Okay, so I think there's a lot of webinars we did about this during lockdown, actually, and we're coming out of lockdown. Sorry to hear that you're getting lots of grievances about this. I think going to the core of the issue, if you've got a really good business case for people to return to office working, that's the kind of cornerstone, or that's the center point of all of this, really. And then it's a reasonable management instruction to request people to return. Secondly, take a look to see what the contractual documents say. If the place of work in the contract is indeed the office, then that's where employees are contractually required to be. Thirdly, just be careful of this. Cases me and Dom are working on today on the other side of the fence, actually. But if people are raising complaints or saying that the office isn't safe for some reason, that was happening a lot during the sort of COVID lockdown time. You've got to be careful about a health and safety related issue or detriment or dismissal even. So provided the office is safe to work in, I'm sure it is, and you've got a good business case for getting people back, you've got a solid ground to kind of push on with this. In terms of grievances, unfortunately, I think best practice dictates that you do deal with them. But again, they should be quite relatively easy to reject if you've got a good business reason to do so. But just be aware of any disabilities or any mental health issues or health and safety issues, or even whistleblowing creeping into this, which would make it unsafe to reject the grievance. I don't know if any of the team got any extra thoughts on that. So in short, I would process the grievances, I'm afraid, unless there's repeated ones, and I think Harry will cover that. Next question: how reasonable is it for a partner to attend a hearing as a reasonable adjustment? So I think this question relates to the right to be accompanied, and which, in accordance with the statute, the Employee Relations Act 1999, the right to accompany only extends to colleagues, people that you're working with, or otherwise a trade union representative. So how is it reasonable for this to be extended to a partner as a reasonable adjustment? So firstly, reasonable adjustments are only relevant if there's a disability involved. If there isn't a disability involved, you've got more control to say no. If there is a disability involved, then yeah, I mean, each case turns on its own facts. But ultimately, if there's a good medical reason to allow a sort of third person, or partner, or friend, or somebody else, not a lawyer, hopefully, to attend the grievance meeting, it's a good idea to do so. And in fact, the Equalities and Human Rights Commission actually lists this as an example reasonable adjustment on their website. So my gut feel is, depending on the severity of the disability and medically why it's beneficial to have this person there, it could very well be a reasonable adjustment. So I would allow it unless there's a good business reason not to. If you want to double check anything with us, of course, drop us a line and we can have a look at the specific case in question. Third question, Dom, did you have an answer for this one?
Yeah, so I'll also read it out. So it's, can you refuse an appeal? The employee always jumps to appeal when they do not like the outcome. I thought appeals should be based upon new evidence, not following one's procedure. Yeah. So kind of like I mentioned, really, if you refuse an appeal, you run the risk of it going against you at the employment tribunal, as it is against the ACAS Code of Practice, but it also may be against any grievance policy that is put in place by the company, and potentially, as I mentioned, a breach of the implied obligations, such as offer reasonable and prompt redress for any grievance. But no, there's no requirement for there to be fresh evidence to justify an appeal. But if there is fresh evidence, as I mentioned also, it may be advisable to have a rehearing.
Yeah, that's right. And just for everybody, everyone's benefit, it's paragraphs 41 to 45 of the statutory ACAS Code of Practice. That does state that you should run appeals. And again, the failure to do that could lead to an ACAS uplift, as Jess mentioned earlier. Okay, we're moving on to the fourth question. Harriet, is that something that you could answer?
Yeah, so this question is about thoughts on an employee continually raising new or additional threads to their grievances, which are not directly related to the original matter once the investigation has begun. Would this impact dealing with the original matter in a timely manner, or would you recommend dealing with each newly raised matter as a new grievance requiring a separate hearing for each? I mean, I would probably say as much as you can to try and keep it as part of the same process. So I think if the issues that they're raising are, and it's as it was, they're not directly related to the original matter, but actually if they could, on a common sense view, form part of that original complaint, then ideally you would try and keep it, because you don't ideally want a separate grievance process for each thing that they've raised. I think if something new has happened and it really is completely unrelated, then it may be best to sort of start a new process and have a new investigator if it required that much investigation. And I think in terms of dealing with it in a timely way, as we've discussed, there are no sort of strict statutory time limits for dealing with the grievance. It needs to be done, without unreasonable delay. And if it's the individual who has then raised a further matter that does require a bit more investigation, then I don't think the employer would be penalised under the ACAS code for it taking a bit more time, because there'd be a good reason why that had taken a bit longer. And it may be, I think if it's something that may take a bit more time, obviously that can be discussed with the individual at the time, and I think it's not necessarily in their interest for there to be a whole new grievance process started, which may actually then take more time if you've got to put a new person in place. So that's my view. I don't know if anyone else has got any other points on that or come across it.
No, that's great. Thanks, Harriet. And I think it sort of relates to the question below that now as well, which is if someone raises repeated grievances, how can the employer deal with that?
Yeah, I mean, I think raising repeated grievances, that might be a slightly different point, I suppose. That might come back to the point I made when I was talking about the Woodhouse case, where someone raises a grievance that's dealt with. A couple of months later, you've got another grievance. They're kind of grievance after grievance, and I think you do have to be really careful there, because you can, from an employer's perspective, this might start to feel very, very frustrating. And thinking, we don't want to have to keep dealing with this. Can we not just, maybe terminate the employee's employment? But I think unless there is sort of clear evidence that this individual is acting sort of maliciously or in a way which may genuinely found some kind of disciplinary action, I think ultimately you have to deal with the grievances. There may be a factual situation where it amounts to a breakdown of trust and confidence, possibly, if it's getting to the stage where the grievances are obviously about nothing. But I think if there's any allegation of discrimination, as in the Woodhouse case, you have to be really careful, because if you then did take action against them, say you keep raising all these grievances, we just can't deal with it anymore because it's taking up too much management time, and they've raised, I think it was a race discrimination claim in the Woodhouse case. If they then do bring a claim for discrimination, it is going to be potentially quite difficult for the employer to sever the reason for dismissal from the complaint of discrimination. They'll say, well, the reason you've dismissed really is because they keep raising complaints of discrimination, and that would then be victimisation. So I think you probably have to try and deal with them as best you can, but it's going to be a very, very fact-sensitive sort of scenario, I think, in terms of whether you actually can take any action against that individual. So yeah, probably take some advice before you take any action against them at that stage.
Yeah, that's great, Harry. Thank you. And I think I echo your thoughts about taking legal advice before acting with this type of case. It can be quite tricky. It's always good, I think, to commercially look at the risk underlying what the grievances are about. If the grievance is something, I don't know, like I wasn't happy with the sandwiches provided over lunch today, there's no real teeth to that grievance. And sorry, it's a really bad example, but ultimately, if you're having repeated grievances if there's no statutory claims attached to them, then there should be no tribunal claim, therefore no ACAS uplift will apply, for example. So commercially, look at each case on its, you look at each individual grievance, and if there's a pattern going on, you may say to the employee, put him a neck on the block here, and if there's a load of grievances coming through about absolutely pointless, nothing points, and you can say to them, unless you've got something substantial, we will not be dealing with your grievances. Potentially, it's a bit risky. Again, take legal advice on that one, but I think you can get to the point where you can just refuse to play ball with this as well, I think. Okay, and then again, if there's no statutory claims attached to the grievances, then the risk of not dealing with them is significantly lower than if it's a fresh discrimination allegation or something. Okay, conscious of time, so moving very quickly. I've got a couple of questions left. Oh, sorry, I think I just cleared one by accident. I did. So just going back to that one, apologies, Philippa. So your question was, you have a question regarding investigations. To conclude this stage of the procedure, is it best to complete an investigation report of all of the evidence? Quick answer to that one is it's not essential, but it is recommended. And the ACAS guide on conducting investigations refers to, so just get the exact wording here. Yeah, it's not essential, but a written investigation report will be beneficial in many cases. And the ACAS guide on investigation sets out what should be in the investigation report. Okay, so hopefully that's answered that question. Just one question left, I should say, which is, how would you suggest dealing with a scenario whereby a person a grievance is raised against raises a counter evidence grievance against the original complainant, please? What a lovely question to end on. Okay, Harry or any of the rest of them can jump in on this as well.
I can jump in. I mean, I think it depends on what you think the motivations are for the individual. It comes back to the point I raised about malicious grievances. If it's a scenario like the one I raised in the tribunal case, where somebody's raised a serious complaint that was about sort of sexual harassment, and then the individual ends up raising a grievance against that person, which seems to clearly be retaliatory because someone has raised something serious that potentially was valid. You may not then necessarily want to deal with the grievance if it's clearly malicious. I think often this can happen where it's not malicious, that somebody raises a grievance and actually there's something else that's happened and they're not happy with something that person's done. Obviously, two people have just really fallen out. I think you would have to hear the second grievance because it may be just as valid as the first grievance. So I think you probably then you have to hold a separate grievance process. And I think as a result of those grievance processes, there'll be findings that may then lead to, does any disciplinary action need to be taken against either of these individuals, which will then be run as a separate process. So that would be my view.
Yeah, I think that's absolutely right, isn't it, really? And then you would always be looking to see whether either grievance would trigger a separate a need for a disciplinary process to be run against either of the employees. But I think the important thing is you don't ignore one of the grievances in favour of the other, because that would be a breach of the ACAS code in itself as well. But yeah, so definitely look at both grievances, run the fair process with both of them, and then if any follow-up action is required. Obviously, we haven't really mentioned this too much today, we're looking at the legal processes, but informal resolutions, always a good thing as well. Workplace mediation can be a really good thing where two people are really going at each other and really hate each other. You can try to fix things. You'll reduce the amount of grievances you have in the future from either of them as well. So do look for practical solutions, but importantly, don't neglect the grievance process. I think that's the main thing, isn't it? Okay. All right, looks like there's no further questions unless anybody sneaks them in very last minute. Thanks so much for attending with us today. Really appreciate it. We'll be back next month. The proposal is to run a similar session on the disciplinary process, a different process. And just to remind everybody that the information we've covered today is accurate as of 4 o'clock on the 29th of September 2022. I really appreciate you being with us, and that's all from us today. So thanks very much for attending. Have a good evening, and bye-bye.
Bye.
Bye.